Hello estate planners. In this video I'm going to explain how to use the HotDocs document assembly system for preparing Chipman Mazzucco estate planning documents. First, to get into HotDocs, you go here. See, it says developer. Yours will say HotDocs user. So I click on that. It opens up HotDocs, and this is the estate planning library. When you want to open up one of these templates, all you do is highlight it, and then we are going to assemble. You will see a new answer file prompt. It is asking you if this is a new answer file or whether you want to use some old answers that you have saved. If this is a totally new matter, you don't have any answers saved anywhere, you'll just click on OK here. But if you do want to go into use old answers, you can click here to see old answers you have created. Or also, it may be the case that you want to get answers from another file, in which case you would click on that and see the answers there. But if the answers are not in the subdirectory you are working in, you may have to import the answers you want from another subdirectory. You can navigate to the other subdirectory to wherever your answers are. Here are the questions that need answering in order to prepare this document. I'm going to prepare a revocable trust agreement for a fictitious client whose name is Howard Smith. I'll just start typing in the information. You tab from one thing to the next. Howard K. Smith. I'll say that he's a junior, he's male, street address. I'll give him a fictitious address. One fictitious road in Hartford, Connecticut. The zip. I don't know the zip, but we'll say it's 06555 and he's married. Look what happens when I say he is single. There are some questions here that go away. If he's married, we are prompted for his wife's name and also whether she is a U.S. citizen. So I'll put Mary Smith and I'll say she is a U.S. citizen. The system does not include qualified domestic trusts yet. How many children does the client have? You have 3 selections. 1 child and do not anticipate more. 1 child but assume more to come, and more than 1 child. I'll answer more than 1 child. Does the client have, or should we assume the client will have, a child under age 18? We'll say yes to this question. That's going to generate different versions of the document. One important thing would be the guardianship appointment. This question is about trusts after the grantor's death. It says, will the client's will or revocable trust agreement provide for a trust that may be established after the client's death, including a disclaimer trust for the surviving spouse? So if this plan is going to involve any type of trust that will continue beyond the grantor's death, the answer would be yes. In this case, we're contemplating a trust for the surviving spouse, at the very least a disclaimer trust, and also trusts for younger children until they're old enough. This is going to be a revocable trust that involves a pour-over will, so the answer to the pour-over question is yes. The pour-back question refers to the revocable trust pour-back plan. That's a plan where the revocable trust terminates at the grantor's death, where all the revocable trust property gets paid back to the grantor's estate so that the trust for the surviving spouse can be a testamentary trust. We do that in Medicaid planning situations, but it doesn't apply here because we have a pour-over plan, not a pour-back plan. So we'll answer the pour-back question no. About generation skipping tax provisions, we usually say yes to this when it's a relatively high net worth client and there's a possibility that a trust for a child might exceed the generation skipping tax exemption, so I'll say yes here. So then we go to the next frame and we have questions about initial trustee selections. There are selections for 1 trustee, 2 trustees, or 3 trustees. This is the initial trustee, so this will be the trustee who is going to serve while the grantor is still living. And typically, for married couples, it will be 2 non-bank trustees, which may include the spouse. So we'll click there, and you will see the questions that follow. We already have the grantor's name, and we already have the spouse's name, so it won't prompt for those, but it will prompt for successor trustee selections later. I'll talk about these tabs at the top of the screen in a few moments. I just want you to be aware of them now. But first, let's talk about trustees. Is the grantor going to be a trustee? I'll answer yes. Does the client want to name the client's spouse as a co-trustee? I'll answer yes. When answered that way, you will see that the names of the co-trustees here below disappear, and the names of the grantor and the grantor's spouse will show up in the document as co-trustees. Now I'd like to show you these tabs at the top of the screen. As you're answering the questions, you generate a document preview. This is not the final document that you'll be editing. It's merely a preview, and it will change as answers to the questions change. So you see here that Howard K. Smith is the grantor, and he and his wife, Mary Smith, are going to be the trustees. If I had answered the questions differently, this would look quite different. We'll go back and forth in the preview as we go through this tutorial. We just answered who will be the initial trustees, and now we're asked for the date on which the trust agreement is to be signed. You can leave this blank because you may not know. This is the way it will look if you leave it blank. It will say the blank day of blank 2016. If you do happen to know the date is April 25th, you can pull down the calendar and select the date. Now you see what it will look like, the 25th day of April 2016, but we don't know when the document will be signed, so I'll leave it blank. Moving on to the next question, how many children does the client have? Let's say that the client has 3 children, and now we're going to provide the names. We will say April Smith and Bobby Smith and Charles Smith, and then we go on to the next question. Should we include the residence and trust provisions? This question is getting at whether the client might put his home in his revocable trust. It's not unusual for a client to do that. Maybe you won't do it right away, but if there's a good possibility of putting the home in the trust, then we would say yes here. One reason why he might not, he might be perfectly fine owning his home jointly with right of survivorship, but there's always a chance that if he's a survivor, he will ultimately want to put the residence in the trust. So we frequently put in the residence and trust provisions. Here, we'll put in the provision. Sometimes the client will have business interests that are going to go into the trust. We're going to answer yes here because I want to show you an example of the type of business provisions that are included if you answer yes. But not everybody has a business. Obviously, if the client doesn't, you answer no. So let's go on. Gifts of cash. Would the client like to include one or more gifts of cash? I'll say no here, but if the answer were yes, it would go on to ask follow-up questions about the legacies to be included in the document. General dispositions of tangible personal property. We have 3 selections. One is that all tangibles be sold and the proceeds added to the residue. One is to include specific instructions regarding tangibles, and the other is not to include any reference to tangibles. The way we have evolved over the years is that we do prepare a document that purports to transfer all tangible personal property to the trust. So we need to include a trust provision to dispose of the tangibles, and that's what we are getting at with this question. Then we ask different questions regarding how to dispose of the tangibles. Does the client want to direct the trustee to sell one or more items? We'll put no here. But if the answer were yes, follow-up questions would ask about which items you want to be sold. This question is about specific gifts of tangibles. Does the client want to include any specific gifts of tangible personal property? The example here is I give my collection of baseball memorabilia to blank if blank survives me. So if the answer is yes, questions about the specifics would follow, but we'll say no. Next question. Whether to include a general gift of all tangible personal property. That usually takes the form of everything to spouse, but if spouse does not survive, then to children as they agree. One thing I want to point out is that this estate planning document assembly system is built in the assumption that there are children. If you have a client who doesn't have children, then you'll have to think of the will for children that's closest to what you want and then do some heavy editing. We'll get around to providing alternatives for clients who don't have children eventually, but it is a difficult job because it's very difficult to predict in advance what people who don't have children might do to cover all the contingencies. Anyway, we'll put in yes here. We want the general provision that gives all tangible personal property to spouse or children that I just described. Then we use the same approach when it comes to real estate. We can include a direction that all real estate be sold, or include specific instructions about real estate, or we don't include anything and let it pass according to the residue. We'll select Include Specific Instructions, and then you'll see now we have a multiple choice type of prompt with different possibilities for the residence. The principal residence to spouse is already checked. You can have more than one of these checked, but if you check one that is inconsistent with another one, you need to uncheck that. You can sell specifically identified real property. You can say the principal residence is going to go to the spouse. Obviously, if you say retain the principal residence as part of the residue, that's inconsistent with the principal residence going to spouse, so you might have to change an answer. You can say other specifically identified real property will be given to the spouse, or you can say principal residence to non-spouse. That's also inconsistent. So you have to be careful not to have inconsistent answers here because the multiple choice selections do allow inconsistent answers. It's up to you to monitor whether there's an inconsistency. For now, I'm just going to say principal residence to spouse. These are distribution possibilities for a surviving spouse. We have outright to spouse without a disclaimer. We have outright to spouse with a disclaimer. We have all to a trust. Now this is a trust that's designed to accomplish Medicaid planning goals. Although if this type of trust is established under the terms of a revocable trust, it really does not deal with Medicaid planning goals very well unless it is a poor back revocable trust. So you need to be careful about that. Other possible selections include an outright marital deduction bequest with the balance to an exemption trust, otherwise known as a B trust or a family trust or a bypass trust. We include a Q-tip marital deduction with the rest to a bypass trust or exemption trust, and we have different combinations. We have reverse Q-tip combinations here too for generation skipping tax purposes, so you pick whichever one you need, and I'm going to pick the outright marital deduction form with the balance to the exemption trust, which is the traditional marital deduction formula type of scheme. And then we have the distribution scheme for descendants. The first selection is outright no trusts. This follows a per stirpes pattern, so if all the children survive, each child is going to get a share at some point. Then we have one big pot trust. We also include one big pot trust, which splits up into separate share trusts. And we have different separate share trust options. One is for lifetime, one is for no interim distributions, but with termination at a specified age, and then we have a couple for interim distributions. I'll do the one with one interim distribution and with termination at a specified age. For the next question, we have a termination age for the separate share trust. When is the child's trust going to terminate? I'll put in age 40. When I did this, I included a multiple choice prompt for interim distributions that were based on 1/3 or 1/4 or 1/2. My most common one was 1/4, so I'll select that. And if the client had in mind some different proportions at different ages, then there would have to be some editing done. Let's see what the document looks like in the Document Preview tab.